and hold me like I do, 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 and
All right, we're here. We made it. And look, perfect timing. They literally have just started. So we timed it just perfect, you guys.
Good morning.
Oh, wow. Thank you, boss lady. I appreciate that. Thank you, Danny. I appreciate that as well. Welcome in, you guys. I don't want us to miss any of this. So thank you all for being here. I appreciate it. And also, hold on a second.
All right.
Thank you, Margie. I'm glad
Right,
you guys
please be
like the
seated.
intro. I appreciate it. And Caitlin, what you doing, boo? All right, here we go. Let's see what kind of hairdo will Lori have today.
Vallow Daybell, CR 2021 001704.
Your Honor, for the record, this Trini K on behalf of the state, and for the record, the next of kin and the victim in the 2022 matter are appearing virtually.
All right.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
Go ahead and announce.
Lori Daybell.
All right, thank you. My courtroom assistant said there's some.
Oh, Christ. Hold on. Ah, what happened? No. Oh my God, you guys, I'm so sorry. I clicked wrong. Cripes. Hold on. Where's that at? Bruh. Hold on.
You can have, if you can fit 3 chairs there and investigate.
I was going to ask. And the victim in the 2022 matter are appearing virtually.
All right.
Lori Daybell on behalf of Lori
Good morning, Your Honor.
Daybell.
Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
She decided against the Shih
ahead and
Tzu
announce.
Cowardly Lion
Lori
hairdo.
Daybell.
All right, thank you. My courtroom assistant said there's some issue with advisory counsel at the table.
I apologize, Your Honor. I didn't think about the logistics, so I'll just let Ms. Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings.
Fantastic. She's not giving us any bootleg Jennifer Beal a la Flashdance. She's not looking like the demon version of Charo.
So that you can have, if you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
I don't know that they can fit 3 chairs and Lori's audacity
Thank you,
at
Your
the
Honor.
same table,
right.
but that's just me.
I just received word literally 2 minutes ago that we will be using Judge Kemp's courtroom, and we can use it for the entire first trial, which is in the South Court Tower, which will give us more space as needed. have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it. That's my proposed questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors in follow-up. So this is not limiting.
All right, just really quickly. No, I don't think she's actually getting highlights like in a professional capacity. It's possible she's using peroxide or something to that effect. Danny, the trial date. So the trial date, her trial officially starts March 31st. It starts with jury selection. They have said that they believe opening statements would be the 7th or the 8th. So there you go. All right, here we go.
What would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses in a little more detail, especially as it pertains to how people perceive officer testimony. And some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues such as pretrial publicity or opinions people may have had or exposure to the case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member's been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it, about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
I agree with this judge. Also, my MK says lack of Botox got her looking like Dave Mustaine. LOL. Oh, what an apropos comparison, you know, because just like the Pied Piper led rats through the streets, wasn't Chad similar to the Pied Piper? Mm-hmm. Good call, MK Leanne. She definitely aging like milk.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder. That's on my desk. Before we,
Defense filed that on the 12th of March.
okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay. All right. Let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right.
Okay, I'm curious as to why the state doesn't think that they're going to be able to pick a jury in that first week. I personally suspect that it's not coming from the state. I think they think that Lori is going to be difficult. I don't disagree. I think she is going to be difficult. So Margie says, I thought there wasn't allowed to see the kids' names. What Lori wanted to do is Lori wanted to use the statements that Alex Cox and Tylee made after Charles Vallow's death. And the judge said, no, that's not going to happen. You murdered, and you've been found guilty of murder respective to Tylee. And so you don't get to benefit, which was the state's argument. You don't get to benefit in some capacity from their death by then using their statement. See, Tylee, because of Lori's actions, cannot come in and testify about those statements, what she meant, why she said what she said. She can't be questioned by either side. And so the right thing is that those statements don't come in. Same with Alex. Alex is not living, and he cannot come in. And so because they cannot be questioned about those statements, it is considered hearsay, I believe is what the judge said. But also, more to the point, they're specifically with Tylee, you cannot murder someone who then you want to speak on your behalf. Like, that's not how it works. So once again, Lori, you suck. That is all. Let's keep going.
Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew.
While they're just shuffling paperwork here, let's rewind and hear what she did say. Let's see.
No, I'm good, Your Honor. Thank you.
All right.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew.
I didn't catch it, you guys. Did you? I didn't hear what they said.
Disclosure. All right, so I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And, well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own sub-right or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously.
Let me stop you right there, Lori. I don't know if because you carry around so much audacity that you lost your manners, but your investigator who was speaking, you're incredibly rude. Further evidence, as if we needed more, that she just is not a good person.
Obviously, that's where I got the people from
I'm gonna rewind it because let's hear all her rudeness in its entirety, no interruptions. All right, here we go.
searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
Okay, Lori, but
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
could you please use your inside voice? This is a courtroom. You're not, controlling the yard at the prison. Lori. Also, there's a difference between the law enforcement interrogating people or interviewing people and the state prosecutor. So you need to understand the difference there. Also, I don't know if it has escaped you, but the rest of us on planet Earth, when we move, most of, over the years, people move, they change addresses, they change phone numbers, etc., particularly after being part of two different trials in this horrible, horrible case. And now we're going to go through a third. None of the rest of us on planet Earth don't use portals to move around. We actually physically have to move. I don't know why you're calling Nate. I don't know what you think he's going to bring to your table, because I hope Nate gets up there and reads you for absolute filth. I know he won't, because he's a gentleman and he's a professional, but I don't know what you could possibly hope to get out of Nate Eaton other than, him to tell, I just don't get it.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
Yeah, what's the relevance
So,
though,
Your Honor, the point
Lori?
is to start with.
Why is Nate Eaton relevant to your defense in any capacity? I mean, I mean, it's going to live on the internet forever. When he asked you, where are your children, Lori?
With one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out there as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial.
Yes, Clicker. Hold on a second. Clicker over here with the rational thought and the most likely scenario which is to keep him out of the courtroom and unable to report the trial. Yeah, that's probably exactly what she's doing. But I still, it's dirty pool, Lori, dirty pool.
Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if he got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the, let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dworkin says, that
Well,
would
it
put
could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
Lori, I have to point this out to you, which I'm sure that, you're aware of. Are you hearing what they're telling you? What they're telling you is even if by some miracle there's some, glitch in the space-time continuum and your investigator can get all of the things that you want done, or even most of the things that you want done, you realize that there's a chance that all of the work that you're asking this man to do might not even be admissible? Are you hearing this like with your listening ears? You idiot.
More than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me,
This is why when you are a pro se defendant, Lori, which I'm sure that you're aware of because you and Sarah Boone have being the smartest person in every room in common. Of course, I kind of wonder what would happen if the two of you were in the same room. Who would be the smarter one then? But anyway, I am sure that you're aware that this is what makes it difficult when you're a pro se defendant. See, the idea of pushing for a speedy trial happens because you have a lawyer, right? And it's never the defense's job to put on a case. It's only the state's job. They have the burden of proof. And a lawyer would be able to expeditiously move through this. And also, that's why they push for a speedy trial. But see, you have so many issues, right? That you have an entire encyclopedia Britannica of issues, let's be honest, just generally speaking. But then on top of it, you're trying to defend yourself while you're incarcerated awaiting trial because, oh, that's right, you've been found guilty of murder in Idaho. Anywho, that's why it's taking so long. So which do you want? Do you want time to prepare an adequate defense, or do you want to have a speedy trial? Because, Shug, you can't have both.
you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay.
I mean, I don't understand the pushing for
So
the
I guess I'm
speedy
gonna have to-
trial. Like, where you got a hot date, Lori? You got somewhere you got to be? I mean, the only place you got to be is back in Idaho to serve the rest of your time, which means the rest of your natural life. I mean, do you understand that? Like, have you masked at all? And Stars Align, well, yes, I think she's being held in the same jail as Jodi Arias was. Jodi has now moved to the big house. She in prison.
Across the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your Honor, the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions.
So, Stars Align, no. So when you see, she hasn't been convicted of anything in Arizona yet. She will be, but not yet. So for her, she would be held in the county jail. That's where they would put her since she hasn't been convicted. Like what happened with Richard Allen, and I'm not going into like guilt, innocence, or anything like that. What happened with Richard Allen being held in a prison prior to his trial, like while he was awaiting trial, is something that is atypical. It doesn't usually happen.
But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting my
copies
paralegals
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
I love the fact that Lori hasn't even asked to have her handcuffs off during court, during the pretrial. You know, smartest person in the
Judge.
room all the time.
I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need, but I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial. and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can.
Damn, Lori, your shenanigans are taking up my whole
And then there's going
summer.
to be some dark days there toward the end of June, but we need to get it done by July 4th.
Just kidding, y'all. I ain't got nothing
When are you
planned.
planning on starting that?
Hold on, Lori. You're so rude. So rude. I was speaking. I don't really have anything planned. I don't have anywhere I need to be. If Lori's representing herself in that trial too, whether she is or isn't, I'm going to stream that trial. So I don't give a rat's fat kneecap. I ain't got nothing to do, Lori. I ain't got nothing but time. Let me rewind this just so we can hear Lori's interruption. She's so rude.
Dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be the starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you
will-
want me to, I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
No, Lori. He wants the name of Chad's mitigator. Of course you're a mitigator. You're the defendant, you idiot. You're the only one who has a mitigator. What a dummy.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Back the milk truck up. You're who? Your husband? She's so disrespectful. Ugh, I can't stand her. Now he's your husband? Disgusting. Also, let me tell you guys, if you're not familiar, what she's asking for. She claims that there is body cam footage from the Gilbert, Arizona Police Department where she is being interviewed at a table and they're coming in and out, and that it was available on the internet. Now, y'all, I have searched high and I have searched low to ascertain what she's talking about. No such video exists that I've been able to find. The only thing that fits what she's describing is from Chandler, not Gilbert. I don't know what she's talking about. Here we go.
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another.
So Little Red says they have done the extraction and only needs the record, not the entire phone. Okay. I can't even believe I'm going to say this, but I learned from the Todd Mullis post-conviction relief hearing that depending on the software that's used, that software gets updated, and that there are times when, because of those updates, the extraction extracts things with the updated software that they may or may not have been able to extract prior to the update. And so it is advantageous for them to do their own extraction. So I understand why she's asking for this. But I also think she's being ridiculous. I don't think they're going to find anything new or useful in her defense with doing another physical extraction, but they might. I don't know. I've been wrong before.
Their extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
All right. So let me look again. I'm going to look this up again because this is, I don't know that is at Gilbert. Let me look it up. Okay. Let me see. Let me look. Hold on a second. I'm looking, you guys. Talk amongst yourselves. Hold on a minute. All right, this is from Chandler. Chandler. I'm sorry, you guys. There's a lot of Lori Vallow interviews and or interrogation. I put interrogation because I know if I put interview, it's going to come up with Dateline. So, let me put it in like this. Oh, Lord, we're going to be here for days. I kind of think I know what you're talking about too, Marjorie, because I know I do recall that interview. It's the one where, exactly like you said, Melanie Gibb, Tylee, and the officer. But what she's asking for is not that interview, right, that we all saw at the table. I think what she's asking for is the body cam from any of the officers coming in and out of that room. That's, I think, what she's asking for. I think she has. I mean, yeah, I can hear it. Here's one right here. Let me share this one instead.
Lori? Hey, Officer Patelli, contacted us.
Wait,
Okay, yeah.
hold on a minute. She does. I got it mixed up. You're right. She does want she wants something that I don't think exists. She wants the full room video is what she's asking for. And I don't the only thing that exists is this that she says is online. Okay? It's this. See?
He's acting like that.
And they've, blurred Tylee out, but this is all that there is. I will, let me stop sharing this. Let me go back and see what else I can find that is anything similar to that. I mean, there's stuff in the news, but I'm not sure that what she wants exists. Yes, Shaggy, that's what she wants. She wants the interview before that whole situation. Yes, when she tried to when Charles tried to get Lori, Charles wanted Lori evaluated. He really thought that she was a danger to herself and to others. But what she's asking for is a vantage point that I'm not exactly sure exists. Okay, Kitty, you did. So Kitty says, I'm nearly sure I saw a different video of Lori and Tylee being interviewed where Lori is sitting in a comfy chair. There is that. And that is from Chandler. And that is after Charles Vallow was murdered. What Lori wants occurred when Charles Vallow called police in Gilbert because Lori had taken the kids and his truck was missing when he came back from a business trip. And I think what she is asking for is what was released online from Gilbert is from the vantage of body cams. She wants most interrogation rooms, right? They have their own video and audio recording. She wants that. I don't think that that exists because it wasn't. It's not like they were when they were talking to Melanie and Tylee and Lori that day at the Gilbert Police Department. She wasn't being interviewed or interrogated as a suspect. And while there may have been the option to record what was taking place in that interview room, it doesn't mean that it was turned on. Like interrogation room video or interrogation rooms sit empty for hours and hours and hours. They have to be to record the audio and to record the video. It has to be turned on. And because this wasn't a formal interrogation and all of the officers were wearing their body cams, I think that the Gilbert Police Department felt like that was enough documentation. I don't think that exists. And I think that what she was shown is this. Hold on a second. I think that her former attorneys, showed her this video. This is all that exists from Gilbert on the internet because she made a big kerfuffle about it being on the internet. It's online. Everybody in the world is viewed it. Blah, 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 blah. Yeah, we all have. So that doesn't, I don't think it doesn't exist, not on the internet anyway. So I don't know if she is confused about what she's asking for and they showed her something different. But as far as what is available online, what is on the internet is that video I just showed you. So, and yes, Lori, we did. We viewed and we judged. Sure did. So, it seems from the way that this hearing concluded, and let me just say this. Let me answer Kristen. So, Kristen, that's one of the. I accidentally. Well, no, I didn't accidentally. I intentionally said when I scheduled this stream last night, I just said use the details, and when I did that, it did it from the live from whatever day that was that I can't remember now. The previous pretrial hearing. I'll just edit the description. I forgot what I put in. I forgot that I had that in the description. And so I need to go back and change that. So I'll just edit it. They're not going to preclude cameras from being in the courtroom. The judge she's already asked for this. And the judge already told her NO spells no. So it's not happening. What else? Marjorie says she came to report the theft of her purse and they were trying to help her get it back from Charles. Yeah, there was several situations, all that. Yes, that's correct as well. So, Michelle, I already did the Slender Man video today. I already did, already played Morgan Geyser's interrogation in its entirety. Tomorrow, we are going to start with I believe that they're I'm gonna have to go look. Ideally, there was some pretrial hearings that occurred prior to God, I can't stay focused on. Now I got to completely get my brain back over to Slenderman. So after the girls were arrested and charged with premeditated, or excuse me, I think it was um, intentional attempted murder. They were charged initially as adults, and they and Morgan and Anissa's defense teams both worked really hard to try to get their cases heard in juvenile court. And no, babe, it's not you. It's me. It's me. I should be able to switch from back and forth. I mean, it's not that difficult. I don't know what my problem is today. So no, don't apologize to me. I should be apologizing to you that I can't change topics that quickly today for whatever the hell the reason is. So ideally, I'd like for you guys to be able to hear that stuff. If I can't find it, then what we'll do is I'll explain to you guys what took place in the interim, and then we'll go right into day one of Anissa Weir's trial. So it's just weird that I don't know what my problem is. I don't know what something has happened inside of my brain. I think maybe it's listening to these to people like Lori represent themselves. Boone broke me, y'all. Between listening to Boone and Owens, my brain is like, bruh, I'm done. I don't want to talk about it anymore. I don't want to hear about it. Like, my brain is just done. Oh, wow. Thank you, Kimberly. I appreciate that. Kimberly says, I've always been interested and followed the Slenderman case. I appreciate you going over it. Yeah, I've always found it to be an interesting case, but I actually think that one of the reasons I was drawn to the Slenderman case is because it's a broader conversation that I think needs to take place, and an important one, and that is, how do we deal with children in the criminal justice system? And I feel like it's such a complex issue, and I don't know that there is a pat answer for that. You know what I mean? I don't know that there is one solution for every case. So but I do think the conversation is worth having, and that's what I want us to do. Yes, Rachel, none of us are the same after Boone. And Michelle says, I just really like you, Allie, and MJ, and will love when I can watch just you three. I don't watch TV anymore, just YouTube. Thank you so much. I appreciate that, Michelle. And it wasn't my frustration. I want you to know sincerely, it was not at you. It was at my own brain that it just wasn't working. I don't know what was wrong with it. It was like stuck on buffer. So annoying. And what else was I going to say? Yeah, 10-10-7-7. I'll never forget that. So yes, KD, also mentally ill children and mentally ill people in general. How do we deal with that? Because, it's complicated and it's multi-layered. And I just, I think it's a conversation worth having. So Lil Red says, why would she not want cameras? It would clearly show she was innocent to the world on camera. LOL. I'll tell you what I suspect. It's not, Lori knows if she's got even one rational brain cell operating in that gourd of hers, she has to at least consider the possibility that she's going to be found guilty, right? And I don't think it's about that at all. I think what it's about is control. I think she wants to control the narrative and control what information gets out there. You know, Lori can say whatever she wants with respect to the media, but at the end of the day, you know, Judge Boyce didn't allow cameras in the courtroom during her trial. Okay. Everything that we heard from her trial, we heard, which we, because there were no cameras, the only thing that was allowed was audio, and the audio could only be uploaded after the day was over, after all the testimony had concluded. And I think that, in a way, I think that there were people who, if the trial had been streamed, they would have watched, but because it wasn't, they found it difficult to follow because it was just audio. Myself, I will say this. I actually thought following just listening to the audio and having no visuals was better for me personally. As you guys may or may not know, some of you are surely aware that when there's when there's video, sometimes I will pick up on things that have nothing to do with anything. They don't make a difference to guilt or innocence or the credibility or the weight of the evidence one way or another. They're just weird observations that I notice in the courtroom that I comment on that will then become a distraction for me later. Like it's the only thing that I can focus on. So actually not having that was kind of a reprieve for me and my brain. It made me actually focus a lot more on not just what was being asked and the answers, right? It made me really focus on the way the question was asked, the tone in which the response was given, all of the things. So I think that it was it was actually a good thing for me. But I think Lori is more about, she wants control and she wants to control the narrative. And that's why, if she really cared and wanted to make sure that she did everything in her power to ensure that she got a fair trial and that the jury pool wasn't tainted, she would never have done that interview on Dateline. So for her to now argue that cameras in the courtroom would prevent her from getting a fair trial is utter poppycock, Lori. You heard me correctly, Lori. I said utter poppycock. It's ridiculous. So it's one of the lamest and worst arguments you've come up with yet. I don't know. That might not be true. I think her allocution at the end of her trial or during sentencing was the worst argument or the worst thing it's come out of her mouth. Saying, that JJ is happy and busy and referring to Tammy as her friend. I don't give a rat's fat kneecap how good of a person you are. Forgiveness takes time. Listen, Tammy Daybell very well could have forgiven Lori for, being the mistress, right? Forgiveness is not for the other person. It's for you. Okay. But forgiveness doesn't equate to friendship. Okay. I can forgive people who've done me dirty. That does not mean I want them in my life. I would imagine that for me, I can't say how Tammy feels but I feel like it's insulting to refer to Tammy as her friend. First of all, Lori, you don't do your friends like that. Okay. You don't sleep with your friends' husbands. Okay. That's not cool. It violates every ethical code there is, including girl code. It's wrong. Chad's wrong too, but we're talking about you here. So it is what it is. She's ridiculous. Tammy is her, yes, ATS summed it up. Tammy is her friend and she has 2 husbands. I mean, yeah, it is what it is. Yeah. Like, if you're my friend and you sleep with my husband, I can forgive both of you because I will need to forgive both of you because I'll need to move on and be okay I still have to go on with my life, and ain't nobody make me. I ain't going to let nobody break me either. Okay. So I could forgive. It would take time, but I could forgive. That does not mean that the friendship door would ever be open ever again. The friendship door would be closed, locked, bolted. I would take that thing to Monsters Inc. and put it through the door shredder. Okay. We're not fixing to be friends at all. I couldn't trust you after that. And there is no any type of ship without trust. Okay. All right. That's my last rant for today. Tomorrow, depending on what we hear in the Sunderman case, I might be on a totally different rant. Because as you know, I do love to get up on the soapbox. It's getting down that's hard. Got that bad back and all. All right, you guys, I want to thank you all so much for being here, for listening and supporting me. I appreciate it greatly. Also, be looking out because we will be discussing the ghost hunter, the wife, and the lifer. Okay, we will be discussing the situation with Aaron from Ghost Hunters, his wife, and what's his face? Grant Amato. We will be discussing that situation. Okay. We will. Just give me a moment. I got to get some stuff taken care of, and we will absolutely be discussing that situation. I'm trying to come up with a clever name because something about that whole situation, I don't know, some play off of the butcher, the baker, the candlestick maker. I feel like there needs to be some type of title like that. So I definitely want to talk about that situation. So be looking out for a live during the night. I've got to coordinate my schedule with my friends because I don't like to go live over them. So thank you, Shaggy, for gifting a membership. I appreciate that so much. Thank you. Thank you. I think, let me switch something right quick. I want to give you guys the old outro for today. I think we need a little levity, and the old outro has much more levity. It's rather new, Kimberly. This is something that just happened. So yeah. Anyway, thank you guys for being here. If you haven't done so, do your girl a favor. Give me a thumbs up or a thumbs down, whichever way you feel. I'm not fixing to judge you. But have a great rest of your Tuesday, and I will see y'all tomorrow. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious.
Finish her!
Minutes later.
We all do a little math sometimes.
And you know this, man.